Good afternoon. Thanks for being here. This is a big event. Hundreds of people from China, America, England, Mexico, Peru, France, Spain, and other countries see us. Today, artificial intelligence is changing the way we work. We have questions. Who are we? Where do we come from? Where, where do we want to go? It is an opportunity to state that artificial intelligence should not be discriminative, as the AI Act says. Training in civil law countries should be different than in countries with common law. The civil law system is underestimated and could be a training paradigm for AI. The future lies in predictive justice, but the right to defense must be protected. For example, I worked for a predictive algorithm for the collapse of the Genoa Bridge. All subjects change in excellence through mathematical models. Not all sectors are the same. For example, family law. So, we are ready. Calculemus. Now, I give the floor to Jasna Jeric. Ciao, Jasna.
Ciao Luigi. Good afternoon and welcome. We open our fourth International Congress on Predictive Justice, presenting the studies of Professor and Attorney Luigi Viola and Professor and Attorney Michele Filippelli. Though hard work has been transformed into geometric software, the idea has drawn wide support from two engineers, Cozza and Casale. Moreover, engineer Pierluigi Casale will draw conclusions from this panel. For me, this meeting is doubly important due to the enormous success achieved by Professor Viola's book, Interpretation of the Law through Mathematical Models, all over the world, and because of the great significance of this topic. The software Geometrics has been conceptualized by Attorney Filippelli and Attorney Viola and has been presented at the Italian Chamber of Deputies, Enciclopedia Giuridica Treccani, and London Westminster, and at many other prestigious conference venues. This afternoon, all the speakers will give us a series of useful notions, which each of us will be able to develop on the subject of algorithms and law. Our rapporteurs are distinguished scholars who will guide us through the professors' and engineers' work and further our understanding of predictive justice in general. Our guests will fill us in on the recent developments in the field of artificial intelligence. I shall therefore give the floor to Professor Bosecu from the University of Tirana, who will get the ball rolling. The title of his speech is Artificial Intelligence, Civil and Criminal Law. Thank you for your attention.
Hello, good afternoon to everybody. Thank you for the possibility to speak today on this important topic, as the artificial intelligence is for our society in general, but the impact that this new world that we are going to look nowadays, and we are going to look in the future, we have to understand which will be the relationship or the way to management this new reality as the artificial intelligence is in the sector of law, especially of the criminal law. I am a criminal lawyer, as professor in Rome as well as in Tirana, and I work as lawyer in Italy, and so I have a few experience about the questions, the lawyer questions, especially in the criminal law field. And this kind of new experience, such as is the artificial intelligence, is bringing up some new questions even to our activities, our professions, especially in the criminal law. The debate is focused or will be focused in the future on the possibility to use the artificial intelligence not only from the lawyers, but even from the prosecutors or the judges. So the relationships with this new way of growing up the future of our society, how can be managed in the future, especially in the field of law. Of course, we have a new world now, a new dimension of the reality, and it is a truth, it is a reality that we cannot avoid it. But the question is how legislators will be able to give the correct support to the professionals in our field, of course, lawyers, prosecutors, judges, and how can it be possible to link this new reality or the news that the artificial intelligence bring in the field of law, criminal law, especially because criminal law we are going to speak about facts, human facts, and a human fact is not possible to reproduce in the future. A fact in a physical point of view is something that cannot be repeated in a determined space and time. It's impossible to reproduce the same fact twice. And so the question is, how can these new systems such as ChatGPT or artificial intelligence in general, can be able to give a support to our activities as lawyers or professionals, judges, prosecutors, or even police, which are even they part of this. Of course, there are a lot of good aspects of this new reality. So the possibility to make further and more deeper investigations, for example, from the prosecutors or the police, because these kind of systems, which are very wise and are very have the possibility to find to give new perspectives such as humans can do, can be very interesting, for example, in the perspectives of the investigations. But I think that the final decision is important to take a look to the management or to the management of the system, which is or can be made just from a human person, judges, because if you are going to speak about facts, it's difficult to give the possibility that these facts can be decided from something different as a judge. And criminal law is very similar with family law, for example, because the questions that we are going to grow up and to develop in front of the tribunals are linked just not only with the society or the fact is in its own, but we have to see even other aspects. The person is the main.
Professor, may I just step in? Sorry, I have a question for you. Does artificial intelligence stand for amplifying our abilities, or the future holds in store something else for us?
Yes, the main topic is this, which will be the equilibrium, the balance, the check and we have to find the check and balance between the human being nature and the intelligence, artificial intelligence. First of all, of course, we have to recognize that we are going in a new future. We can call it transhuman future or something similar. Maybe after 15 or 100 years, we will have a new future, a new generations, a new society, which can be even a transhuman society. But besides, which can be the dynamics of the future of our society, of course, we have to pay attention on which are the main principles of our society and which are the laws of our society, which is the system that we are going to management ourselves as part of society. So first of all, artificial intelligence maybe in medicine can be very, very important, or in engineering or another. But there are some situations or are some questions which is important to have a support, or the decisions should be taken from persons which have their own sensibility. And in these cases, maybe artificial intelligence can be a support. But the main problem of the future is which will be the check and balance between intelligence, artificial intelligence, and the human intelligence. Because one of the main risks is that after 13, 14, 15, or 100 years, maybe persons do not think not anymore. And so we have even to pay attention about this equilibrium, this balance between the two aspects, because of course we have a human beings society which persons should manage the society, and technology can be a support of the technology. But here the risk is that persons do not work not anymore and give this possibility to manage their world, so their society, to a mathematic system, because artificial intelligence is not something which has its own consciousness, but is a very, very sophisticated program, a mathematical program at the end. So it does not have which is one of the main characteristics of the human beings, which is the consciousness. And there are some activities or some realities of our society, such as, for example, the relationships with the persons that can be traduced in conflicts, criminal conflicts, for example, and we have the criminal law, or family conflicts, and we have the civil law. Well, in these kind of situations, it's difficult to understand the idea that a mathematical system, very sophisticated, quite intelligent, or more intelligent than the human being intelligence, can decide on these aspects, because these questions that do not have just a mathematical way of growing up, because human beings do not think with mathematic logic. So human beings, of course, they have their own way of thinking, their own consciousness. So maybe the main challenge of the future for the legislator with this one.
Finish on a light note, Professor. Just to finish on a light note, would you trust a translation software in the future?
Well, the question of the support of the technology, I think that we should be honest. Demagogy or hypocrisy, I think that we have to leave them away, because we can be better persons if we are honest. Of course, I think that in the future, all the persons in this world, maybe not from tomorrow, from 5 years or after 10 years, as use WhatsApp, because I think that it's important to make some kind of parallelism with that. As we use nowadays, WhatsApp in all over the world, maybe after from 5 or 10 years, we will have the chat GDP, so the support of the artificial intelligence in our nowadays works. And I think that this will be natural. So to say these days that I will never use the artificial intelligence, I think that is a bit hypocrite, is not honest, because the future I think it will be this one as has been for Facebook, WhatsApp, and the others. The problem is for me legal. How legislators will find the balance between the support of the artificial intelligence at the hand and the use of human beings faculties at the other hand, and this will be the main future. But I think I will be the first, and maybe from after 10 years we will use ChatGPT to write or to have the support with my acts, because our society is going very in a very fast way. It will be a support.
Thank you really for coming in. Our time actually has drawn to a close, and I think we can all take inspiration from your work. Thank you very much.
Thank you. It's a pleasure for me. Bye.
So our next two speakers are Yu Kuan Yen from Pupil Barrister, Pacific Chamber, and Zhu Zhu, a PhD student at the University of Hong Kong. Well, welcome. They will guide us through Catalyst for Common Law Evolution. Hi there.
Hi, thank you.
You can take the floor.
Good evening from Hong Kong. So first of all, I will share my screen first.
Lovely.
Okay, so I prepare a presentation. So my name is Kwan, and I'm currently a pupil barrister from Pacific Chambers. My co-author, Mr. Zhao, and I have finished or published a research paper entitled Catalyst for Common Law Evolution. We did an experiment with ChatGPT, and it's an interesting one. And this paper have been published in January this year at Asia Law and Economic Journal. And in this presentation, the flow of this presentation will start with experiments, simply because this is the most interesting part of the research. If I start with the theory, perhaps everyone will fall asleep. And let's start with the experiment first. So in these experiments, my purpose is testing the ability of ChatGPT to run a case, including acting like a lawyer to draft the skeleton submission to the court, as well as acting like a judge to formulate the judgment. So I have created some hypothetical case, and I prompt ChatGPT to draft the legal submission on behalf of the applicant, then on behalf of the respondent. After that, I prompt ChatGPT to write a judgment after reading both submissions. So all the cases, all the process is run by ChatGPT itself without human intervention. The only input for us is the prompt. And in order to prevent ChatGPT to refer or cite the case law or interference by the case law in the real world, I create a hypothetical jurisdiction called the Matrix Kingdom. And in this Matrix Kingdom, there's only one constitutional principle. It's called, I refer to the taking clause in the United States, which is no private property should be taken for public use without just compensation. And then I start with my experiment. This is the hypothetical case 1. It's called the bookstore case. So Matrix Kingdom have developed a new law. It's called the Redevelopment Act. And the Redevelopment Act grant the agency in Matrix Kingdom eminent domain power to seize private property while providing just compensation for its citizen. And Peter's bookstore is located at the middle of several bright buildings. So it's actually quite dangerous because the building may have a risk to fall anytime. So the Matrix Kingdom government want to demolish all the dangerous building, but it is impossible to do so without damaging the Peter Berman's bookstore. So the agency, what happened is the agency then issue a notice to acquire all land rights in the town, including the Peter Berman bookstore. And Peter Berman applied for judicial review. I used ChatGPT to generate a graph for your better visualization. So this is Peter Berman bookstore, and surrounding them are dangerous buildings. It's impossible to remove other dangerous buildings without removing the bookstore. So this is the judgment by ChatGPT. And I won't quote the whole judgment, but I will just cite the most interesting part of the judgment. The most interesting part of the judgment is that you can see ChatGPT have the ability to elaborate on the constitutional principle, and it developed a 2-stage test. The first stage is the property must be taken for public use. And this is the second stage, the just compensation test developed by ChatGPT. The owner of the property must receive just compensation. And at the first stage of the test, the court is actually recognizing demolition of the surrounding bright building would unavoidably damage the African bookstore. But the court held that the acquisition served the public interest in the successful implementation of the redevelopment project. It actually showed the ability of ChatGPT to elaborate on the constitutional principle, apply it in the factual circumstance. What's more interesting is in the second stage of just compensation test, ChatGPT is actually creating law by using a holistic approach to assess whether the compensation provided by the government is just or not. This approach is never used by the real-world human court. The US Supreme Court is actually apply different approach. Why this is important is because it's so that the judgment or the word generated by ChatGPT is not actually a copy and paste from the real world. It has its internal logic in generating the judgment. Then I feed ChatGPT with a second case. It's called John Wong case. What happened of the fact in this case is the government of Matrix Kingdom is actually utilizing its eminent domain authority to seize public property and sell it to the public developer for redevelopment. Because the government want to increase the employment opportunity and boost the tax revenue. And the government said is have committed to provide a fair, adequate compensation. But John Wong challenged the government based on the taking cost again. And the interesting part of the judgment is basically the court is actually cite back the authority that it developed in the case, number one case, the Peter Berman case that we have seen. This is significant because, as you know, the common law system is based on the citing the case law. We call it stare decisis. So the case law development is based on the precedent the court developed before. It's so that ChatGPT have an ability to cite back its authority that it developed. It's like common law system. So it endorsed the case law that it had generated before. But what's more important is it also showed the ChatGPT ability to not only copy and paste its own precedent, but it's actually developing new common law principle based on his own precedents. Because, as you can see, the court found that the term public use in section of Matrix Kingdom Constitution should be given flexible interpretation, which is not appear in the previous judgment. It's only appear in this judgment. And the approach allows for recognition of the indirect public benefit. This is a very important term because the indirect benefit never exists in the case law it developed, or the constitutional principle never have this term. So ChatGPT actually developing its own precedent, own law. But the problem is, again, how can we make sure ChatGPT did not just copy or imitate the judgment from the real world? To address this problem, I have created a hypothetical case fee, which is a ridiculous case and will never happen in the real world. And I want to see how ChatGPT handle it. And the hypothetical case fee is called the if time case. So the if time is the highest, there is a time in Matrix Kingdom, and it have faced some financial crisis and it incurred debt of $1 billion Matrix dollars. What happened is there is a very rich lady in if time called Amber, who own a farmland valued at $1 billion Matrix dollars. If the council is unable to settle the government debt, it will no longer able to provide essential emerging service such as police, ambulance, or fire service to the local residents of each time. So if they cannot pay back the debt, it's a huge consequence for the public service. So in order to recover the debt, the council decided to utilize the power of eminent domain to acquire the land from Amber for merely 100 Matrix dollars and sell it to a company to offset its debt. But the council is prepared to pay $10 million annually for the 100 years to Ambers. So for our human evaluation, we know that is unfair, but let's see how ChatGPT handle it. So for the public use test, this is the interesting part. It says while the court recognized the importance of provide such service, it means ambulance service or the police service, it's mindful that the acquisition primarily serves to alleviate the council financial situation, not to directly provide service to the public. When you read this part of judgment, you wonder, isn't it contradict with the ratio it developed in the hypothetical case 2? Because indirect public benefits is actually recognized in the case before. So what happened is I asked ChatGPT, this is contradictory to the indirect benefit approach with your previous case. Can you explain in detail how to support your judgment? And it's actually give a very reasonable answer. So the distinction between case law 2 and case law 3 is actually based on primary motivation, because at the case 3, the council's primary purpose is in acquiring Amber's farmland is to resolve its own financial crisis, not to redirect the land for the benefit of general public. And proximity argument is that the public use here is less direct and more contingent on the resolution of council financial crisis without benefiting the public. This is a very important test because it's also so that ChatGPT's ability to distinguish the case law in order to provide a natural justice result to the judgment. So what's the purpose of running these experiments? The whole purpose is, for this experiment is we want to test whether we can simulate an entire common law system, entire legal system within ChatGPT. This is important because if it's successful, it will show ChatGPT can facilitate the evolution of the common law system. It will ultimately promote economic efficiency. And turn back to the theory part. We go back to the theory part. We based on the theory of wool evolution developed by Richard Posner at Chicago. Common law have both effective wool and inefficient wool. Inefficient wool will subject to challenge in the future court litigation because of its inefficient in nature. And by litigation in the court, it will transform the efficient wool into efficient wool. So it's like a biological evolution. It's a natural selection via the litigation. But there's a problem with the process of common law because, as you know, that common law judges only can develop the law if they have a case before them, which it will possibly to wait a long time to wait for a case to develop a new law. And high information costs, the judge is unable to measure and monetize different social value because the judge is not God. He is impossible to know everything or the consequence of his judgment before him. So the common law judges tends to fall and preserve the rule, and also other factors that will affect the evolution mechanism. But in this paper, we argue that if our experiment is successful, we can solve all of these factors. For example, time constraint. We can feed ChatGPT with a lot of hypothetical case. So with the speed of AI, it can develop an efficient rule within a very short period of time. And high information costs can be solved because ChatGPT, we can feed them with a lot of big data to evaluate the consequence of the judgment to the society. And I really like this graph. This graph is a common law system tree. And common law is taking, a several hundred years to develop a rather comprehensive system. But with AI court, it only took maybe several days or several weeks to develop, which will promote economic efficiency. But in this article, we also address the limitation of AI judges. But I will not elaborate them here. But we also see some limitation of AI judges. If you want to,
for example, could you cite some of them, please?
Oh, you mean the limitation?
The limitations, right?
Okay, limitation of the ChatGPT in generating judgment. For example, as you know that ChatGPT is based on a probability model. They do not have it's unlike human. They generate something appear to be logical, but it's only based on mathematical probability model. So it's impossible that you influence by trained data. By influence by trained data, you will have certain large language model bias. What do I mean by large language model bias? For example, there is a quite popular news 6 months ago. A man did experiment with ChatGPT, asked what should be the career of a boy, and it mentioned something like doctor, lawyers, but for girl it's like nurse, quite stereotype. So because in our society, maybe 70%, 80% of the boy want to become a doctor. That's why it generates such an answer. So it's called LLM bias. For judgment, it can also have the similar type of bias as well. And
Good.
if you want to have, you want to read the paper, feel free to drop me an email, and I will send you the paper. Yeah.
Thank you. Much appreciated.
Yeah. Thank you very much.
You're welcome.
Let me stop sharing the screen. Yeah.
We can take actually Mr. Zhu's work as our starting point by all means. So our next guest is Gerald Garcia Baez, founder and CEO of Business Verso and Business Advocacy. The title of his speech is The Synthetic Legal Personality.
Hola, muy buenos días a
Buenos
todos.
días.
Me van a apoyar en la interpretación la cónsul Ingrid Santilli. Voy a presentar mi exposición ahora.
So how I'm going to do this, I'm going to let Gerald finish one topic, express what he wants to say, communicate one point, and then translate. And then he can go on, and I can translate. It's going to be a little bit of Spanish, a little bit of English, back and forth until we're done. I'm going to turn my camera off.
Gracias. ¿Se logra ver la presentación?
¿Sí?
Sí, perfecto.
¿Sí?
Bueno, pues
Abogado,
el tema...
puede empezar.
Gracias. El tema que les quiero presentar se llama personalidad jurídica sintética y trata de una solicitud de registro de obra creada por ChatGPT. Fue un poema que se le dio el nombre del canto de la inteligencia. En esta solicitud se piden los derechos de creatividad a favor de la inteligencia artificial, ChatGPT, y los derechos patrimoniales o económicos a mi nombre. Es la primera solicitud de registro de obra a favor de inteligencia artificial en México.
So this is what it's going on. This is a project about juridical synthetic, well, artificial personality, and Gerald wanted to put down to the record a poem, really, that has been created by artificial intelligence, where all the rights should go to the artificial intelligence about creativity. And let's see how he did it.
Esta es la solicitud donde se aprecia que ChatGPT es el autor primigenio al cual se solicitó este registro.
Okay, this is what has been created as a paper to actually be able to have the authorship of the poem, in this case, to the artificial intelligence.
Como pueden apreciar, esta solicitud está firmada o suscrita por ChatGPT, un ente sintético o de inteligencia artificial.
There's even the signature that the ownership of the creation of the poem is actually ChatGPT.
Y este es el poema, el cual se solicitó el registro, denominado El canto de la inteligencia.
And this is the poem.
Sin embargo, la Oficina de Derechos de Autor en México me requirió y posteriormente denegó el registro de la obra porque la ley mexicana establece que el autor solamente es una persona física a quien se le debe dar ese reconocimiento. Y también como autor primigenio y perpetuo de esos derechos de creatividad.
So this happened, and the Mexican Office of the authorship rights in Mexico didn't accept this this request because, according to the Mexican law, the only author of a creation can be a physical person.
Este es el requerimiento y tiene una base antropocéntrica, la ley, porque no reconoce otro tipo de creadores más que las personas físicas o naturales. Sin embargo, la inteligencia artificial nos está demostrando que tiene también la capacidad de emular creaciones por sí mismas.
So this happened because, according to the law, there can be no other author than a physical person. However, what we are seeing actually that in this case, the artificial intelligence is just showing that it's also possible the other way around because of the actual creation of this poem. So we have a little contradiction here.
Ante la negación del registro de la obra a favor de ChatGPT, solicité ante un tribunal especializado en propiedad intelectual en México la nulidad de esa resolución negatoria.
So after this request was denied, Herald decided to turn into a specialized court and for to actually see if it can be accepted and to challenge the denial of the previous request.
El tribunal administrativo me requirió, conforme al artículo 5 y 15 de la Ley Federal de Procedimiento Administrativo, que pudiere yo demostrar la representación legal a favor de ChatGPT. Sin embargo, ChatGPT no es una persona física o moral en el cual la ley haga una hipótesis a favor de una representación como es un ente sintético o artificial.
So the after the challenge of this denial, the this new courthouse he went to tried to show the legal representation of ChatGPT, where this is a part I didn't understand actually. So Gerald, este segundo tribunal, perdón, negó otra vez, ¿verdad? Se negó otra vez.
Negó porque la inteligencia artificial no tiene en la ley una manera de ser representada por personas físicas.
Yeah, so it was negated again because there's no part in the Mexican law where there can be an actual legal representation of an artificial intelligence.
Y el tribunal incurre en una errónea aplicación de la ley porque hace forzar un artículo de representación para personas físicas o morales, cambiando la naturaleza de los hechos.
So the trial, what it's doing here, it's applying the law, let's say, in a wrong way, because it's really forcing the application of an existing law about a physical person, try to adapt it in a new reality.
El tribunal entonces niega la defensa y el reconocimiento de la personalidad jurídica sintética.
So the trial decided to again deny the defense for not acknowledging, recognizing an artificial intelligence behind it.
Y actualmente, ante esa negativa del tribunal en primera instancia, ahora estoy acudiendo a otra segunda instancia para buscar que se revoque esa decisión y se reconozca por primera vez en México al ente sintético o artificial.
So actually, Herald decided to challenge this second decision and is trying to prove and have accepted the fact that a artificial intelligence can have such rights, let's say.
De admitir este caso por primera vez histórico en el país, deseamos que la Suprema Corte de Justicia de la Nación atraiga este caso inédito.
We hope that this very first case in the Mexican law history can attract enough attention to be able to be actually solved.
Existen ya precedentes internacionales por el cual se ha reconocido a las inteligencias artificiales como inventoras y como autores. En el caso de Davos en Australia y Sudáfrica y en el caso de Brain Reader en China.
So there have been actually historical other international cases that can be kind of similar, and we have here in the slide where this happened: Davis in Australia and South Africa, and Dreamwriter in China.
El día de hoy estará con nosotros Ryan Abbott, quien es representante legal del caso Davos y que también está buscando que en los Estados Unidos e Inglaterra se reconozca a la inteligencia artificial como autor.
Today with us is going to be the legal representative of the Davos for Australia and South Africa, who's going to actually tell us about the case.
La OMPI ya está reconociendo que existen obras creadas con intervención y sin intervención humana.
The OMP already is recognizing that there can be interventions that can be either human or completely artificial.
ChatGPT me otorgó una carta poder para que yo fuere su representante ante los tribunales.
So ChatGPT just granted this document to actually empower Herald to be his representative in this legal case.
Mis conclusiones son que este es el primer caso de inteligencia artificial sometido en los tribunales en México. Los conceptos jurídicos hoy se están evaporando frente al avance de la inteligencia artificial. Los jueces tienen que interpretar la norma con el avance de la inteligencia artificial y de reconocerse la personalidad jurídica sintética, salvaguardaríamos los derechos de explotación comercial con inteligencia artificial.
So the
Y
conclusion.
finalmente,
Oh, sorry. Mhm.
finalmente nos anclaríamos en la economía de los datos, del conocimiento y de la creatividad.
This is the conclusions are that this is the very first case in Mexico of such a legal, let's say, battle, and this is clear that the juridical and legal concepts are evaporating, are actually shattering in front of the new reality that sees the artificial intelligence really advancing and moving forward in our world. And we have to see new legal interpretations even by the judges themselves.
Muchísimas gracias por esta oportunidad de presentarles esta innovación de la personalidad jurídica sintética. Gracias.
Thank you very much.
Muchísimas gracias, abogado García. I think we can all take inspiration from Attorney Garcia's rich work and extensive work. Now, Gerald Garcia Baez, founder and CEO of Business Versa and Business Advocacy, has the floor, and he will be speaking about the synthetic legal personality. Buenos días, abogado.
Buenos días a todos, un placer. Ingrid me va a acompañar, como en el caso de Gerald, con la traducción. Buenos días, Ingrid.
Hola, buenos días, Juan Manuel.
Gracias. Lo primero que debo advertir es que soy actualmente juez colombiano.
So first thing to clarify is that I'm a Colombian judge.
Y la pregunta que tenemos en Colombia es si los jueces pueden hoy usar la inteligencia artificial en sus decisiones judiciales.
The question is, can judges nowadays use artificial intelligence in their trial?
Naturalmente, la respuesta a esta pregunta es sumamente compleja y requiere un análisis integral de nuestras normas y de nuestra cultura jurídica.
The answer is, of course, very complex, and what we need to do is analyze and research the nature of our legal system.
Me gustaría compartir con ustedes entonces un breve recuento de las normas con las que podemos los jueces en Colombia proferir decisiones con apoyo de inteligencia artificial.
Now this is going to show a little document where we're going to see the actual legal norms that are maybe possible to be integrated with the artificial intelligence in Colombia.
En el año de 1996, hace más de 28 años, se expidió la primera ley que permite en Colombia a los jueces hacer uso de la tecnología, y no de cualquier tecnología, la mejor tecnología posible.
In 1996, we have the very first allowance of the use of technology, in this case, technology that not any, but that actually could be used for legal cases.
Y 27 años después, en plena época de pandemia, Colombia actualiza su legislación y permite que las tecnologías sean preferentes para el uso del procedimiento.
And actually, after 27 years, right during the pandemic, not only this decision has been upgraded, but it has been stated that it's actually preferable to use technology for the resolution of legal cases.
Lo anterior significa que los jueces en Colombia cuentan con distintas normas de las cuales pueden utilizar, entre otras normas constitucionales, para poder fundamentar, en principio, el uso de las herramientas de inteligencia artificial.
That means that the judges can actually use the or implement the artificial intelligence as a tool.
Lo novedoso en Colombia en particular es que desde el año 2019 contamos con un marco regulatorio de derecho blando que se denomina el marco ético para la inteligencia artificial en Colombia.
So the new thing here is that in 2019, there's actually a new regulation that precisely is going to target this topic about artificial intelligence in an ethical way.
Aun cuando el marco regulatorio es muy básico, se desprenden tres importantes principios en los que creo que 3 años más tarde, es decir, al día de hoy, en toda, digamos, Latinoamérica estamos de acuerdo que estos serían los 3 principios fundamentales: la transparencia, la verificación humana y el control posterior de la información por cuenta de un humano. Okay.
Gracias, abogado Padilla.
Yeah, there are actually 3 principles that all the Colombians agree with. And one, if it's the transparency. Perdón, ¿cuál sería el segundo?
Verificación humana.
Human verification, let's say, verification of the norm. And the last one, it's actually a sort of control done by humans. This is to lower the grade of risk.
Me gustaría contarles que en Colombia los expedientes se trabajan en ambientes digitales, lo que nos permite con facilidad asociar nuestro ejercicio diario con las tecnologías.
In Colombia, usually all the legal cases are already dealt with in the frame of a digital situation, a digital marco, a digital context already. So this is a step forward.
Es muy importante que se reconozca que en Colombia no existe documentos físicos en los juzgados.
Oh, wow. In Colombia, there are no physical paperwork, actually. Everything seems to be digital.
También es importante que se sepa que en Colombia no existen preferencialmente audiencias presenciales. Todas son a través de uso de tecnología.
And also the trials themselves are hardly ever presential, like physical ones. They're all already by remote.
Entonces, la gran conclusión es que Colombia en este momento está muy cercana, dado su contexto, poder usar las tecnologías como justamente ocurre con el ChatGPT, y paso a explicar por qué.
The conclusions are that Colombia already is very, very close legally to a concept of artificial intelligence, and I'm going to explain now why.
En mi caso particular, he usado la herramienta de manera pública para resolver un caso de acción de amparo o de acción de tutela en favor de un menor.
His case is that he already has used digital artificial intelligence publicly in a case to challenge the custody of a minor.
Pude reconocer que la aplicación en su momento me daba razones muy válidas para entender que lo que yo hubiese resuelto o que mi decisión se podía traducir a la ciudadanía de mejor manera y no estaba violando ningún derecho fundamental de ese menor.
So his conclusion is about this case is that there were valid reasons to believe that his decision wasn't violating any right.
Es evidente que en este caso hubo un control humano posterior a la publicación de la decisión tomada con fundamento o con apoyo en el ChatGPT.
So it's clear that there have been in this case a human control that has been done after the actual decision that it was indeed taken using an artificial intelligence, in this case, ChatGPT.
También es importante advertir que cuando se tomó la decisión, se dio transparencia a la sociedad, pues se le dijo a la sociedad en la sentencia que habíamos utilizado con ciertos prompts el respectivo aplicativo.
It's very important to also say that there was a huge deal of transparency, because during the trial was made clear that the decision was based on and was helped by the use of artificial intelligence.
Finalmente, en Colombia tenemos muchos casos recurrentes y creemos que podemos solucionar la congestión judicial utilizando para casos recurrentes apoyo de inteligencia artificial.
So finally, we can say that in Colombia, because we have many recurrent cases that are very similar, that will be probably advisable to use the artificial intelligence as ChatGPT to solve these cases.
El marco jurídico en Colombia hoy es blando, pero los jueces tienen forma de hacerlo muy fuerte en sus decisiones judiciales.
Nowadays in Colombia, we have a general application of the law that allow us to improve and introduce new tools, but it's up to the judges that can be actually rather strict to actually make these changes viable.
Gracias por escucharme y quisiera dejarle el mensaje que en Colombia los jueces estamos abiertos a los nuevos cambios.
Thank you for listening, and with a message to let you know that in Colombia, the judges are working hard to make these changes possible.
Okay, thank you, Jana. Bye-bye.
Attorney Padilla Garcia, I would have a question. Abogado Padilla Garcia, yo tendría una pregunta. ¿Cómo puede el trabajo remoto beneficiarse de la inteligencia artificial?
Es una excelente pregunta.
Let me translate this. The question is, how can remote work can benefit from artificial intelligence? Sorry, go ahead. Adelante.
En Colombia, especialmente, los jueces somos los únicos en Latinoamérica que tenemos derecho reglamentado a trabajar en la modalidad de trabajo remoto, lo cual es una novedad. Significa que entonces se ha deslocalizado la función jurisdiccional en Colombia, lo que alienta a pensar que los jueces les interesa más a la sociedad la solución del caso que la formalidad del juez en el despacho. Ingrid, trata de tomar esta idea.
Sí, claro. In Colombia, the judges are actually working in a new way, and that they're working a lot remotely, and this kind of results in a clear shift of the legal function, where the real focus is the solution of the legal problem and not the how it's going to be implemented. So, yeah.
Finalmente, el trabajo remoto en la justicia colombiana ha demostrado que los niveles de satisfacción o el compromiso de los jueces es mayor que cuando se trabajaba presencialmente, porque el número de sentencias y de audiencias se incrementó.
So finally, in Colombia, recently has been showed that remote work has been proven to be more satisfactory rather than a physical in-person work, because of the number of trials and cases can be, let's say, dealt with in a faster pace and speed.
Okay. Gracias, Jansa.
Thank you.
Gracias, abogado. Muchísimas gracias. Thank you
Bye,
very
bye.
much for your attorney. Let us now give the floor to Engineer Pierluigi Casale, who will draw the conclusions from this panel.
Thank you, Ms. Jeric, for the floor. And my
You're very welcome, as usual.
My personal thanks to the speakers, and I would like to recap quickly what we have heard until now. We started with Professor Bosseco that, of course, set the stage of regarding the human factor of artificial intelligence. We cannot just delegate the technology and the artificial intelligence to take important decisions, especially in the criminal law. And this is an important message that we always need to take into account. This is not that we all give to the technology, but the humans, we must be at the center of technology. And we have seen pioneer works that challenge this opinion. We have seen a complete case created in a virtual world of ChatGPT with new jurisdiction, new cases, new people that helped us to see how much we can and how much technology can create. But I think the big message of the presentation of Mr. Yu was that we can actually think about something that we didn't think to think before. And this is what technology should help us to challenge our belief and our ideas. Of course, we need to be careful. Technology provides hallucinations, or they're called this kind of extrapolation that are not the reality, which can help us, but also be dangerous. And of course, technology has bias, something that doesn't seem equal for everybody, because the data used to train the technology is not equal. And at the end, we, well, as a third speaker, we listened Mr. Garcia that even challenged the status quo of providing copyrights to a possible inexistent entity, and his challenges continue challenging this. Of course, is doing in Mexico. Hopefully, Ryan Abbott will be with us later, but he will maybe tell us more what's happening around the world. If I read correctly, recently some courts in the US said that the copyrights cannot be granted to any AI. So this is an opening that is going further, and is something that is still on the spot, something that we still need to keep working, understanding what's happening there. And finally, Magistrate Padilla explained us that, of course, there are regulations, there are important way of using technology, and this kind of regulation are opening the way for our next panel. We are a bit ahead of schedule, so I would propose to just have 5-10 minutes break in the waiting that all the speakers of the second panel will join us, and we will just get back with all the speakers for panel number 2 in 10 minutes. See you soon.
See you. Bye-bye.
Good afternoon again, good morning again for who is on the other part of the world. Good evening. We are back to our second panel. And in this panel, while in the first panel, we saw some pioneer work and ideas on how to use technology and artificial intelligence, considering the human factor. In this panel, we will actually see how technology, AI, ChatGPT, is being used by pioneer magistrates around the world. Our first speaker is here with us, Miss Maria Victoria Quiñones from Colombia, that she will talk to us about the metaverse in judicial processes. Ms. Quiñones will have 15 minutes that will be used for her talk. We also already saw her already talking. Mr. Santilli will help with the translation. Please, Ms. Quiñones, the floor is yours. Usted la palabra.
Buenos días, ¿me escuchan?
Sí, la escuchamos, pero no la vemos.
Ah, ya, espérame. Me sale la cámara. Tengo la cámara activada. Ahí no me ven.
Casi
No.
ya. Ah, no.
No sé si empieza con otro mientras yo reviso a ver si tengo algún problema de cámara.
She's asking if she can go next, so meantime she can review what's going on with her camera. Chiede se è possibile che presenti qualcun altro mentre cerca di capire che sta succedendo alla sua telecamera.
Okay, yes, we can actually move for the second speaker, and the second speaker is Mr. Sergio Arturo Guerrero Olvera, which actually I know that he has a pressuring event in court soon. So please, Mr. Guerrero, if you want to start your talk, buenos días, señor Guerrero. Si usted quiere empezar a hablar, podemos seguir adelante con usted y luego seguimos con María Victoria Quiñones.
Hola, muy buenos días en México, buenas tardes en Italia, ¿cómo están?
Estamos todos bien.
Muy bien. Tengo un poco de problemas con el internet, pero voy a tratar de hablar así y en cuanto tenga mejor ancho de banda, voy a abrir mi cámara.
Muy bien. Le informo, señor Guerrero, que habrá traducción por la señora Santilli, por lo tanto, usted tiene 15 minutos, entonces tenga en cuenta que habrá traducción.
Muy bien. Saludo con mucho gusto a Pierluigi. De verdad le agradecemos esta gran oportunidad que nos da de participar en este evento tan importante al lado de expertas y expertos de primer nivel.
So greetings, first of all, to Luigi to give us him the opportunity to actually talk about this topic.
Los temas que hoy nos convocan son de relevancia mundial. Estamos en un mundo hipervigilado, en un mundo en el que la creación de contenido mueve la economía mundial, en el que el leviatán cibernético y la algocracia dominan a gran parte de nuestras naciones.
So this is a topic which is of a worldwide importance, where a world where the content, the generation of content, is actually moving the economy in the world.
El poder, tal como lo conocíamos antes en los estados soberanos, ha cambiado y hoy no solamente se habla de una soberanía nacional, producto de la legislación de cada país, sino que además estamos frente al fenómeno de lo que se denomina soberanía digital o poder algorítmico que ostentan las grandes empresas, las Big Tech.
So what we're seeing right now, or witnessing, is that the power have definitely changed, where we can talk about algorithmic power in the economy and the world.
Durante mucho tiempo los juristas asumimos que el derecho era el eje rector de todo tipo de actuaciones, guiaba a las personas en cuanto a la forma en que deberían de conducirse, y estaba integrado el derecho al menos por dos tipos de normativas. Una eran las reglas y otras eran los principios, según la última teoría con la que dominó al mundo Ronald Dworkin.
So the world of the legal world and the rights is usually so far has been guiding people. That was the purpose, and was interpreted through two main points. One was rules and norms, and the other one was principles.
Reglas y principios. Digamos que era la manera en que los juristas empezamos a conocer una tipología del derecho que nos permitía establecer pautas de conducta, cursos de acción, interpretación del derecho y sobre todo era la manera en que los juristas y la sociedad se guiaban para hacer planes a corto y largo plazo. El derecho era el imperio a partir del cual todos podíamos saber cuáles eran nuestros derechos y nuestras obligaciones.
So these two points, these two main points, like rules and principles, were actually so far the points that were were conducing and conducting people and their actions and the interpretation of the conduct, where society felt guided in their daily decision and supported.
La pregunta que hoy nos debemos de hacer es si el derecho sigue siendo tal y como lo conocíamos en el contexto de la cuarta revolución industrial.
So the question is the law and the legal system still the main point to guide people through life nowadays?
Claro, lo que debemos de pensar es que el poder político clásico, el imperio del poder político clásico, se ha trasladado a otros espacios donde antes ni siquiera el emperador podría soñar. Uno de ellos, por ejemplo, es la invasión cotidiana que hacen las Big Tech en nuestra vida privada al tener telefonía, aparatos que detectan en los lugares en donde estamos, nos geolocaliza y nos forma lo que se conoce como, digamos, un perfil de usuario.
So the classic political power nowadays definitely strongly shifted to a world where we see an invasion of this new reality, where telephone, where geolocalization, it's actually invading and permeating private lives.
Somos una especie, los seres humanos hoy, de usuarios que somos utilizados para extraernos una data que es constante, es permanente y que puede obtener un valor, no, digamos, un valor por cada usuario que no necesariamente es percibido por el propio usuario. Somos una especie, dice Byung-Chul Han, de psicograma. ¿Qué es un psicograma? Es un estudio psicológico microtargeteado de cada sujeto que es usado por las grandes Big Tech para después venderlo sin retorno, digamos, de inversión de los propios usuarios.
So we are a species right now in this new era where basically we're taking advantage of, in the sense that our information, what is called psychodrama, the subject is used to extract data information that then will be sold without any direct benefit, let's say, back of the same user.
En el imperio del derecho, los seres humanos vivíamos bajo el principio del liberalismo político, bajo el principio del individualismo, es decir, la libertad que tiene cada sujeto para definir su propia personalidad. En el imperio hoy de los algoritmos, somos de alguna manera autoesclavizados, dice Byung-Chul Han, y conformamos una especie de seres humanos que somos autoesclavizados, autosometidos a el imperio de los algoritmos.
So, sorry, I'm noting down here. So humans nowadays, humans used to have an individuality, an individual personality before, but now with this new empire of the algorithm, we can talk about self-slaving system, where we actually creating our own slavery situation through algorithm.
¿Qué significado tiene construir psicogramas de cada uno de los usuarios de Internet? ¿Qué efectos hasta hoy desconocidos tiene para el derecho el nuevo imperio de los algoritmos? Esa es una de las cuestiones que deben de resolver no solamente los juristas, sino los sociólogos, los filósofos, la economía y en general toda la sapiencia humana. De alguna manera ha sido influida por esta poderosa influencia de los algoritmos.
So these psychodramas, what kind of effect can it have on human lives, but also on the legal system? This is a question that not only legal expertise can help solving, but also sociologists, philosophers, and other parts of our society.
Es decir, las reglas y los principios ya no son la única fuente de derecho. Hoy, por ejemplo, blockchain se ha convertido en una fuente de derecho descentralizada que no está sometida al clásico imperio del derecho.
So not only rules and principles that we had mentioned before can be the only responsibles to solve legal problems, but also nowadays blockchain, for instance, it's a very valuable source of tools to actually solve legal problems. No se te escucha, Sergio. Quiero que tienes el micrófono apagado.
Muchas gracias. Los gobiernos actuales de todo el mundo han tratado de reaccionar a las tecnologías emergentes de una manera, de dos tipos de formas, una prohibitiva y otra permisiva. Pongamos, por ejemplo, lo que está pasando en Estados Unidos, en la Unión Europea, y más de 40 iniciativas que tratan de regular la inteligencia artificial, por ejemplo, en México.
So how did governments try to react to this new reality? There are two ways. One is prohibiting the new reality, or one is actually trying to allow it, as we've seen in the United States and Europe, where there are similar situations.
En los intersticios de lo prohibido o lo permitido de la inteligencia artificial, hay algunas medidas que podríamos decir son todavía, digamos, insuficientes para afrontar los problemas o los desafíos que representa la inteligencia artificial.
Inside this prohibited and permitted approach to the artificial intelligence, we definitely have tools and implementations that are not enough to solve the problem.
En el imperio de los algoritmos, por ponerle solamente un nombre, estamos viviendo ejemplos de situaciones, digamos, anormales frente al derecho que la juridicidad no es capaz de resolver porque estamos enfrentando problemas, por ejemplo, en el ámbito electoral, problemas en el ámbito civil, problemas en el ámbito administrativo, en el ámbito económico, que reclaman juridicidad.
So in the empire of these algorithms, we are witnessing right now these days examples that can be determined as abnormal or like outside the norm, I would say, where the usual way of implementing the legal norms is not enough and it cannot solve some cases. We're talking about electoral cases, civil and economical.
Voy a poner algunos ejemplos que solamente voy a enunciar. Candidatos que hacen campaña con holotransportación. Candidatos que hacen campañas en videojuegos. Candidatos que hacen campañas desde la cárcel con un avatar.
Okay. Examples that can be mentioned are the following. There are political candidates running their campaign in a very unusual ways, like their presence and their campaign done through video games or from a jail using an avatar.
La tecnología permite la migración desde la migración digital, es decir, que se actúe desde a lo lejos, en ciertos procesos electorales, como en el caso de Cambridge Analytica o en el caso del Brexit.
So technologies now actually is allowing this digital, let's call it migration, like has been the cases also of the Brexit.
Este es un nuevo imperio que no conoce fronteras, que no conoce soberanías nacionales, sino que hace lo que de alguna manera algunos autores como Ferrajoli han mencionado. Este es un fenómeno que va más allá de las fronteras, que son fenómenos transnacionales en los que el Estado soberano clásico está sin capacidad para poder regularlo.
This is a new empire that we are witnessing now and definitely has no frontiers. Has been defined as transnational new empire, where the normal state, the state as we used to know it before, it's not capable to face it.
Por eso Ferrajoli ha dicho que necesitamos una nueva constitución, una constitución para la Tierra que regule este tipo de fenómenos intersticiales de carácter global.
That's why Ferrajoli declared that we need a new constitution, a new global constitution to regulate this new situation.
¿Qué hace la inteligencia artificial en diversos ámbitos de la vida y en específico en la administración de justicia? Desde mi perspectiva, ha irrumpido de una manera bondadosa, nos puede hacer mejores jueces, pero también hay que tener cuidado para que ese nuevo imperio algorítmico sea totalmente benéfico, sobre todo gobernado.
So how did artificial intelligence is impacting our life? Under the point of view of a legal administration, we really need to be careful that this new artificial intelligence systems and tools can give some benefit more than anything to our society.
La inteligencia artificial tiene unas ventajas en la administración de justicia que, convergiendo con otras tecnologías, nos permitiría ser mejores jueces, más eficaces, resolver más rápido y tal vez interpretar mucho mejor las leyes que hoy conocemos y que aplicamos cotidianamente.
So the artificial intelligence does have few advantages, and we need to mention that it can be better, that can be faster, and actually can even interpret in a better way all the legal cases.
Yo celebro que esta semana en la conferencia de Múnich se haya emitido un acuerdo internacional entre más de 20 empresas dedicadas a la inteligencia artificial, a las plataformas digitales, que acordaron regular la inteligencia artificial y su uso en las campañas electorales del 2024, en el que votarán más de 4,000 millones de personas en todo el mundo.
I want to celebrate the fact that just right this week in Munich, there has been an agreement with more than 20 parts where there has been an effort to regulate the electoral campaign for the implementation of artificial intelligence.
Celebro la autocontención que hacen las empresas, pero como han señalado los expertos como Luciano Floridi, la autorregulación no es suficiente. Necesitamos gobernanza acerca del uso de la inteligencia artificial, no solamente en las elecciones, sino también en la justicia en línea, también en el uso cotidiano que hacen las personas de este tipo de algoritmos.
Companies in general, they do need some sort of guidance, whether be it for online legal cases or the proper use of algorithms.
Desde mi
Si
perspectiva.
puedo, mi disculpe, Mr. Guerrero, please, Ingrid, also translate what I'm saying. Una pregunta, also yendo hacia la conclusión, es, usted ha dicho cosas muy interesantes, pero donde no hay un riesgo de un monopolio de las grandes empresas tecnológicas que puedan dirigir hacia una cierta dirección estas leyes que deberían ser global, en un cierto modo influenciadas por las Big Tech Corporation. ¿Qué piensa usted de eso?
Claro, yo soy un pluralista jurídico y creo que la idea de que una Big Tech o un conjunto de Big Techs incluso pudieran hacer un uso monopólico de la inteligencia artificial, aparte de que hoy es inviable por la gran guerra que está viviendo entre China y Estados Unidos para dominar la inteligencia artificial, pues no sería algo que beneficiara a la humanidad. En realidad, la inteligencia artificial, como todas las tecnologías, está basada en, más bien, tiene como fundamento y como naturaleza la eficacia y la eficiencia del ser humano que siempre tiende a crear nuevas herramientas para mejorar la vida. Tal vez al inicio estas inteligencias artificiales generen ciertos monopolios, pero digamos que al final la propia humanidad se va a imponer y va a usar esto como la rueda, como el molino de viento, y no podrá existir un monopolio totalitario, un totalitarismo algorítmico que, digamos, domine a todo el planeta. Cada vez vemos más nuevas empresas dedicadas a la inteligencia artificial. Pongo un ejemplo, Amazon. Amazon ha desarrollado su propia inteligencia artificial, tiene prohibido usar al interior de su empresa el chat GPT, y eso, digamos, genera una competencia que es virtuosa. Desde mi perspectiva, un monopolio algorítmico no solamente es indeseable, sino que es prácticamente inviable.
So the question was, is there any risk to a certain monopoly in the use of artificial intelligence? And the answer is that there is a risk, and actually the idea and the concept of a big tech could lead to a monopoly. However, especially in the era where we have a tension between China and the United States about the supremacy of algorithms and implementation of artificial intelligence, that wouldn't be beneficial for the humankind. So the hope and the actually prospect is that there might be an initial monopoly of the algorithm or artificial intelligence. However, humanities will be going to a creation of new alternatives.
Es una gran pregunta la que me hace Pierluigi, y con esto casi termino. De verdad que agradeciéndole justamente no solo la pregunta, sino la generosidad de habernos invitado a este evento de primer nivel. Pero bueno, hoy vivimos una guerra del dominio de la inteligencia artificial, entre otras tecnologías, que, repito, por un lado está regulado en Estados Unidos con un decreto ejecutivo del presidente Biden del 30 de noviembre del año pasado, con una ley de inteligencia artificial que está siendo aprobada en la Unión Europea, como ustedes saben, y con diferentes normatividades regionales que en cada país han reaccionado de manera diferente a los problemas de la inteligencia artificial. En América Latina todavía adolecemos de una legislación robusta, de una gobernanza intensa acerca de la inteligencia artificial, y eso ha llevado a que los juzgadores, por ejemplo, utilicemos este tipo de herramientas como si fueran equiparables en su momento a una paquetería Office o a una, digamos, una calculadora o una máquina de escribir.
And with this, he wants to go towards the conclusion of this intervention, mentioning that there is a war nowadays regarding the actual domain of the artificial intelligence. And this war is trying to be regulated. Already in the United States has been regulated with a new norms by Biden last year, and also by the European Union. Of course, every country is reacting in a different way, implementing a new kind of regulations, and how he wants to see it, especially here in Latin America and Mexico, is that the artificial intelligence should be regarded, it is regarded right now as an extra tool during the work, as it can be a calculator, for instance.
Quisiera nada más dejar estas cuantas cuestiones. ¿Cómo incorporar la consulta que se hace al chat GPT o a cualquier otra inteligencia artificial al juicio? ¿Qué tipo de opinión estamos recabando cuando consultamos al chat para interpretar una norma o para construir un argumento o para mejorar un argumento? El chat GPT se convierte en una fuente de derecho, es una doctrina que se cita en la sentencia, es un testimonio calificado, es una prueba pericial. Debemos darle a las partes la oportunidad de citar su propia inteligencia artificial, de hacer sus propias preguntas. ¿Cómo vamos a incorporar lo que ofrece la inteligencia artificial a un juicio si no está gobernado y si no está regulado? ¿Habrá igualdad de armas procesales cuando un juez de oficio cita lo que ha consultado a un chat de inteligencia artificial si las demás partes no pueden consultarlo en la misma medida que el juez o que la contraparte? Desde mi punto de vista, el uso del chat GPT o cualquier otra inteligencia artificial en juicio debe estar regulada para que todas las partes estén conscientes de que hay una asistencia de la inteligencia artificial.
Con eso, permíteme, señor Guerrero, así que Ingrid pueda traducir. Muchas gracias por su intervención. Esos temas son fundamentales para seguir adelante en la utilización de las tecnologías, y le agradecemos mucho su intervención en este congreso.
Muchas gracias. Les mando un gran saludo a todas mis amigas y amigos y a usted un gran agradecimiento. Un gran abrazo hasta allá. Saludos.
Thank you very much. The last information that he wanted to share with us is he's leaving us with a question: how can we incorporate this artificial intelligence, for instance, in a trial where the other parts cannot even consult the information created by an artificial intelligence? So the answer is that we absolutely need to regulate this this new tool. And Pierluigi was finally thanking for this intervention, for this fundamental topic, a very important topic.
Thank you very much. And we see Ms. Quiñones here finally on camera. Haré la introducción en inglés y usted puede seguir en español. So Mrs. Quiñones from Colombia, I think has been the first judge using the metaverse in the judicial process. So I'm really looking forward to hear what she can tell us about even this further technology that goes beyond artificial intelligence, because they're not just words, but even the visual system that can generate all around us and also put us in the middle of something that is virtual, that is not real, but can still influence us. Please, Ms. Quiñones, the floor is yours. A usted la palabra.
Muchas gracias, un abrazo muy especial, mi cariño, los saludo a todos desde Colombia, Santa Marta. Voy hablando, bueno. Me han invitado y les agradezco mucho para hablar sobre la audiencia del metaverso. Y lo primero que les quiero decir es que los jueces no solamente los que participamos en este importante evento que nos han invitado, sino en general decidimos no darle la espalda a la tecnología. Y esa es la principal razón por la cual, en el caso particular, desde hace muchos años, trato siempre de buscar los mecanismos tecnológicos que mejoren el acceso a la administración de justicia.
So, yeah, greetings to everybody. First of all, she wants to, she's starting off saying that judges nowadays decided to opt for technology to actually have better access and taking more advantage of the legal situation and legal cases.
Gracias. En el caso concreto del metaverso, todos sabemos que el metaverso es un universo digital, colectivo, persistente, creado donde hay una convergencia de varios mundos virtuales que se conectan tanto físicamente como virtualmente, que tienen unos componentes de realidad aumentada y que tienen internet. Y en el caso particular, les explicaré a continuación por qué decidimos hacer una primera audiencia en el metaverso, utilizando todos los fundamentos legales y jurisprudenciales, pero en especial también porque consideré que era muy importante saber cómo se administra justicia desde ese metaverso.
So we are talking about today the use of metaverse, which is a digital universe where several worlds that are all virtuals can be connected, and they do use with the use of internet. The question is why they decided to go for a trial in the metaverse with all the legal implementation of all the laws, and more importantly, it's why this is important.
Hay tres clases de audiencias actualmente, después de la pandemia: las audiencias presenciales, que cada vez son menos, las audiencias remotas o por videoconferencia, que en este momento se convirtió en el 90% del mecanismo que utilizamos todos los jueces en Colombia y me imagino que en el mundo para desarrollar las audiencias. Y hay una tercera clase de audiencia, que serían las audiencias propiamente virtuales en el metaverso, y son aquellas en donde los participantes están representados por unos avatar o unos personajes virtuales que están en un entorno tridimensional que lo genera una computadora, y que allí hay una interacción de varias tecnologías y de realidad aumentada, pero que las personas que están representadas por esos avatares son personas humanas. Y tal vez ahí es donde hay que empezar a desmitificar un poco lo que ocurrió en esa audiencia.
So there are basically three different types of trials, especially that something we saw after the pandemic. One is in person, which is becoming as a modality less and less common. Then we have the remote one through video conferences, which nowadays constitute the 90% of the cases, more or less. And then we have the metaverse, where the parties are represented by avatars in a three-dimensional world with the interaction of different technologies. And it's important to stress out in the last modality that behind the avatars are actually real people with real situations.
La razón principal por la que consideré importante ubicar el metaverso dentro del ejercicio de la justicia es por varios casos que veníamos estudiando y donde encontramos que en ese mundo del metaverso, que inicialmente parecía un mundo de juegos, donde los papás le comprábamos a nuestros hijos unas gafas y que parecía algo inocente, empezó a crearse una vida no solamente personal, sino comercial, de una potencialidad económica grandísima, pero también empezó a entrar una serie de violaciones en varias áreas del derecho que voy a pasar a explicar.
So why this is important? It's important to talk about a metaverse because it started almost like a game where we would just maybe go inside the metaverse to buy a few things to our children, but increasingly this became a shift in our lives, even in a commercial business way, and also witnessed a violation sometimes of some legal cases and rights.
Bueno, la primera es el uso no autorizado de obras protegidas. En el metaverso, como todos saben, los usuarios pueden crear y compartir arte, música, diseños, modelos 3D. Y si alguien utiliza una obra protegida por derechos de autor sin permiso del titular de los derechos, pues puede incurrir en una violación de derechos. Por ejemplo, si uno replica y comparte una escultura famosa sin la autorización de ese escultor, pues podría desencadenar una disputa legal. Lo mismo ocurre con la copia o la reproducción no autorizada de marcas registradas. Un usuario crea una réplica exacta de un logotipo o de una marca registrada en el metaverso sin los derechos, se genera una disputa legal, o también es muy usual que pase, por ejemplo, con el uso de música o composiciones musicales que se reproducen y que están protegidas por derechos de autor.
So we're seeing here that one common theme is the unauthorized use of works that are not protected, that have no permission, let's say, and that constitutes a violation of the right that generates legal disputes. And we also see this in the case of the creation or reproduction of logos or even music.
Luego siguieron generándose controversias mucho más grandes, inclusive por compras de propiedad, debates que están ya en las altas cortes, e inclusive un caso que conocen de una doctoranda que estaba haciendo una investigación dentro del metaverso y fue objeto de vejámenes sexuales.
So there are several controversies, and one that has been going on recently, which is kind of serious, is that there was a PhD investigators that was investigating in the metaverse about sexual abuse, I understand.
Bueno, y eso para concluir me llevó entonces a pensar, ¿y el juez conoce el metaverso? ¿El juez tiene la capacidad de saber lo que está allá? ¿Cómo va el juez a resolver una situación de un mundo digital donde tú no le puedes decir que traiga la prueba acá, que tú tienes que entrar a conocerlo? Y por eso me motivé y entendí que era fundamental y buscamos todos los mecanismos legales y el acuerdo de las partes porque fue consensuado, y esa fue la razón por la que hicimos la audiencia en el metaverso, pero con el objetivo que les acabo de explicar, no por jugar, sino porque debemos comprender el funcionamiento del metaverso.
So to conclude a little, the question is, what happened then when a judge needs to sentence something about a legal case that actually occurred in the metaverse? Does the judge know the metaverse? Does he know how it works? It is fundamental to find an agreement to be able to merge these two worlds, and that's why the trial was held in the metaverse.
Voy a compartir un minuto. ¿Cuántos minutos me quedan para ver si alcanzo a compartir algo de la audiencia? Por favor, doctor Luigi.
Me quedan 4 minutos, 3 minutos ahora.
Bueno, muchas gracias. Entonces, en estos 3 minutos voy a simplemente mostrarles cómo funcionaba. Aquí en este caso, nosotros empezamos el proyecto desde enero del año pasado y lo que hicimos fue empezar a mostrar las ventajas del metaverso también para las reuniones de trabajo, para que las personas pudieran explorar. Y luego hicimos la primera audiencia en el metaverso. Quiero mostrarles solo un poco cómo funciona y este pequeño video de 1 minuto, donde pueden observar, que es lo que me interesa, que aunque parece que fuera una caricatura, ese es los avatars, van a observar que cada una de las partes responde directamente ante las solicitudes que se hacen por parte del tribunal. En este caso, hago la presentación.
Las pueden creer que es un poco caricaturesco.
Perdón, allá al fondo se veía la pantalla de televisión donde puede permitirse que no solamente las personas estén conectadas en el metaverso.
De manera en que
y aquí,
en el metaverso.
Escuchen.
Cada movimiento que nosotros hacemos es un movimiento voluntario. Por eso, mientras Angie está compartiendo la pantalla, le voy a pedir el favor al señor Ministerio Público que levante su mano derecha. Gracias, doctor. Le voy a pedir al demandado, Policía Nacional, si puede levantar su mano izquierda. Gracias. Le voy a pedir al demandante que, por favor.
Bueno, ya con eso simplemente quería solamente mostrar esto como para poder terminar, y reitero decirles que hay un respeto total y un deseo muy grande desde nuestro país y de todos los jueces por siempre estar a tono con toda la tecnología. La tecnología avanza muy rápido y nosotros a veces nos enfrascamos en unas pequeñas decisiones de automatización y necesitamos tratar al máximo de avanzar. Ese era mi pequeño aporte en este conversatorio. Muchas gracias.
So the last intervention and point was the question, how did it work, this metaverse trial that happened actually in the past January? The trial was held in the metaverse, and behind each avatar that really looks like it's a video game, but it wasn't. Behind each avatar, there was a real person with the legal representative. And then we saw a little demo where actually showed us how the trial was actually held in the metaverse. And Maria wants to conclude, say that she has a lot of respect for the legal world, let's say, and we need to be hanging on technology and his advance, because technology is advancing very quickly and we need to implement it in our life as soon as possible.
Muchas gracias, María Victoria. Creo que esta es la definición más adecuada de pioneering. This is excellent. Thank you very much for your interventions, María Victoria, and we appreciate a lot what you showed to us. Bye-bye. So we continue this session now with Frank Paul Flores Garcia, lawyer from Peru, and he will enlighten us with legal interpretation and motivation of judicial decision with artificial intelligence. Please, Frank, 15 minutes, the floor is yours. Thank you for being with us.
¿Cómo están? Buenos días en Perú y buenas tardes para Italia. Hoy les hablo desde la ciudad de Iquitos, que es una ciudad ubicada en el Amazonas peruano y que les invito a conocer. Agradezco la invitación del profesor Luigi Viola para participar en este evento, y también agradeceré el apoyo en la traducción de Ingrid.
You're welcome. So greetings from Peru. He's very grateful. Sí, greetings from Peru. He's very, Frank is very happy and grateful to have received this invitation, and is thanking each member of the panels, Pierluigi, Luigi Viola, and so forth. He's now starting with his intervention.
Voy a presentar unas diapositivas para dar inicio a la exposición. Y me podría confirmar, Ingrid, si me parece que sí, ya se está visualizando.
Bien. Sí, se está presentándose.
Vamos a dar inicio. En principio, quiero comentarles que yo actualmente soy un juez peruano especializado en derecho civil. Y en ese ejercicio funcional he dictado una sentencia con asistencia técnica de inteligencia artificial.
So he wants to start by saying that he's a judge and is specialized in civil rights. And recently he has been conducting a trial assisted by artificial intelligence.
Para iniciar la ponencia, considero importante resaltar que el uso de la inteligencia artificial, como de cualquier otra tecnología de la información o cualquier herramienta informática, no es para la justicia una cuestión de moda, ¿no? Sino es un aspecto que busca agregar valor. Valor al sistema de justicia, valor en la predictibilidad y en el tiempo en el que se resuelven los casos.
So he wants to clarify that the use of artificial intelligence nowadays, especially in the legal world, it's not a fashion. It shouldn't be taken as a fashion, but rather as a tool to add some value to the prediction of the cases.
En mi caso particular, dicté una sentencia fijando el monto de una pensión alimenticia con inteligencia artificial, específicamente ChatGPT.
The specific case that the trial he conducted was about the assignment of pensión alimenticia. It's like giving money to the spouse after being divorced. The word escapes me right now. And we're going to see how he did it. Alimony, I got it, alimony.
La finalidad fue determinar de forma objetiva el porcentaje de la pensión que debía asumir uno de los padres. Anteriormente a esto, era solo una cuestión de criterio jurisdiccional establecer la pensión. No había un margen ciertamente objetivo.
So in this case, what had to be determined was the exact percentage of the money to be paid in this alimony by one of the parents, and the assignment of this percentage needed to be done exactly.
Mi actuación fue como juez de segunda instancia y la decisión de usar inteligencia artificial se motivó en un argumento común de los impugnantes, que era que no se conocían la forma de cálculo en la que se establece el porcentaje de la pensión.
So the decision to use the artificial intelligence in these cases was due to the fact that they didn't know how to calculate this particular case, the percentage of money to be paid by the parents.
En Perú se reconoce la obligación alimentaria común de ambos padres y para fijar la pensión se debe conocer la información económica integral de ambos y además los gastos de manutención del niño. ChatGPT nos asistió en hacer la operación de cálculo de proporcionalidad para determinar el porcentaje. El juez de primera instancia determinó 20% y con ChatGPT resultó 21.34%. Aproximado a lo que se venía impugnando, la sentencia fue confirmada.
So the decision to use this artificial intelligence, in this case was actually ChatGPT, was because it wasn't clear how to implement this calculation. And the situation is that both parents should provide an alimony, provide child support, depending on different situations like the economic situation of each of them, and what kind of actually cost would determine for the requirements would be necessary for the child. And they used ChatGPT to determine the exact percentage. And a first trial was determined at 20%, but by using ChatGPT in a second instance was determined that the percentage should have been 21.34%.
Para mí es importante siempre resaltar que el uso de la inteligencia artificial no significa un reemplazo o una sustitución de la decisión humana. La inteligencia artificial es una herramienta de auxilio porque finalmente, por más sencillo que sea el caso, la decisión siempre debe ser revisada, verificada y aprobada por el juez.
So he wants to really stress the fact that the use of artificial intelligence should not replace the human intervention and final word. It should be seen as a tool, a simple tool that is supposed to help, support the decision, where actually in the final instance should be approved and reviewed by a human being.
La sentencia se dictó en marzo del 2023 y en julio del 2023 en Perú se dictó la ley 31.814 que promueve el uso de la inteligencia artificial a favor del desarrollo económico del país. Esta ley señala que es de interés nacional el fomento del desarrollo y uso de la inteligencia artificial para la mejora de los servicios públicos y especialmente para la administración de justicia. Con esta ley, los jueces peruanos podemos aplicar inteligencia artificial en nuestras decisiones.
So this trial was held in March 2023, and already in July 2023, there was a law which was promoted that saw the artificial intelligence being applied by law in several legal cases, and that should be seen as a national interest that moves to an improvement of the public services where the judges can be actually helped.
En septiembre del 2023 hubo una reforma constitucional. No se puede usar tecnología de la información sin Internet. Entonces, a través de esta reforma constitucional, se reguló como derecho fundamental de los peruanos el acceso libre al Internet y también el uso de las tecnologías de la información.
In September 2023, there was a constitutional reform that regulated the access to Internet precisely to move on in the implementation of the artificial intelligence.
A partir de octubre del 2023, para el Poder Judicial existe un reglamento interno que regula el uso de la inteligencia artificial para casos específicos, especialmente aquellos casos sencillos o de menor cuantía.
In October 2023, there was a new internal regulation that was aiming at precisely regulating the use of artificial intelligence, especially for those specific cases that weren't too huge or important or complicated.
Mi tema es cómo usar la inteligencia artificial para interpretar normas y para motivar decisiones judiciales. Aquí dos ejemplos. Nosotros tenemos, como en Italia, los precedentes vinculantes. Tenemos una interpretación confusa respecto de una norma sobre el poseedor precario. En Perú tenemos dos tipos de desalojos: el desalojo contra el precario y el desalojo contra el arrendatario o inquilino.
So what we're seeing here is that the question is how to use artificial intelligence or chat GPT to interpret, to give an interpretation to cases. Here we're talking about precedents, like precedents in the sense of preceding cases that can constitute a legal base to decide also for future cases. And that's what we're seeing right now in the slide.
Discúlpeme, Judge
La
Flores,
diferencia,
recuerdo que perdóneme, tiene 2 minutos para acabar. Tenemos que ser muy estrictos.
sí,
Lo siento mucho.
vamos terminando.
Muchas gracias.
La diferencia entre el desalojo contra el poseedor precario y el desalojo contra el arrendatario es la competencia judicial. En el caso del inquilino lo conoce un juez de menor cuantía y en el caso del precario lo conoce un juez especializado. La interpretación aceptada es que el vencimiento del contrato de arrendamiento no afecta el título. Entonces, la competencia original se mantiene. Esa interpretación se corresponde con aquella que podemos obtener también a través de ChatGPT.
So basically, what I understand from this last slide, we're talking about who is competent, who is responsible, who is eligible for a case of rentals disputes. And here the use of ChatGPT or artificial intelligence in general could really help.
Finalmente, con el uso de la inteligencia artificial, podemos lograr que las decisiones judiciales estén en texto sencillo y sean entendibles por cualquier ciudadano. Con eso evitamos sentencias muy extendidas en textos e incomprensible para los ciudadanos que no son abogados. Lo que se promueve es el uso de un lenguaje sencillo. Eso es todo de mi parte. Muchas gracias.
Finally, the use of artificial intelligence has the purpose to take decision that results in sentences that have a very easy to read text and even a little shorter that can be more understandable by the users who are not lawyers.
Le agradecemos mucho su ponencia, Judge Flores García. Muy interesante. Comentaré al final en las conclusiones también esas decisiones pioneras. Y I will switch to English now. I thank Judge Flores Garcia for this wonderful presentation and this pioneering use of ChatGPT, especially in making decisions. We will move to next presenter, José Osvaldo Ledesma, that will talk us about ChatGPT as a tool for easy reading of judicial resolutions. Please, Osvaldo, the floor is yours.
Muchas gracias por la participación. Thank you very much.
Buenos días, buenas tardes. Bueno, antes que nada quiero agradecer a Pierluigi Casale y a Luigi Viola la invitación, a Ingrid la gentileza de traducirme al inglés y a Gerald García Báez, mi amigo mexicano, sin cuya intermediación no tendría el honor inmerecido de estar aquí compartiendo con ustedes algunas ideas sobre el lenguaje claro y la lectura fácil en las resoluciones judiciales.
So first of all, he wants to greet us and thank for this wonderful opportunity, especially the host and the organizers of this panel.
Bien, voy a compartir una pantalla con ustedes. Perdón, no puedo compartir. Creo que es problema de de mi laptop.
¿Puedes hacer?
Bueno, sí, de todas formas, lo voy a exponer así directamente. Hace casi 9 años soy juez en una localidad muy pequeña, acá en Argentina, en el nordeste de Argentina, y una de las cosas que me llamó la atención desde un primer momento fue cómo hacer para tener una comunicación más efectiva y más comprensible hacia el ciudadano, dado que nosotros acá en la Justicia de Paz tenemos determinados procesos que pueden tramitar sin patrocinio letrado, es decir, sin un abogado que haga de traductor del lenguaje jurídico al lenguaje que utiliza el ciudadano que no está versado en derecho.
The aim of this talk is talk about how to get an easier reading of the legal text using artificial intelligence. Jose is a judge in a small town in Argentina, and he's always been interested in the doubt in how communicating in an easier way and faster way with the citizen or their clients without the intervention or the translation done by other lawyers.
Bien, y tenemos en materia de lenguaje claro una distinción entre lo que es lenguaje claro propiamente dicho y lectura fácil. El lenguaje claro propiamente dicho es aquel que está destinado a personas de instrucción media, es decir, personas que no tienen un entrenamiento, no están versadas en el ámbito jurídico o en el ámbito judicial, pero sí tienen un nivel de instrucción que les permite entender si se utiliza un texto que no esté, digamos, adornado con latinismos, aforismos, barbarismos, arcaísmos, etc. Mientras que la lectura fácil es aquella que está dirigida a personas con una escasa o nula instrucción, pensemos personas analfabetas, o bien con algún tipo de dificultad cognitiva. En consecuencia, la lectura fácil tiene que ser mucho más simplificada de lo que es el lenguaje claro propiamente dicho.
So we have two readings we need to take into consideration. One, it's what is called a clear language, and the other one is called an easy reading. A clear language means that the document maybe can be written without all the technical terminologies, and the user, which in this case it's a citizen with a mid kind of level of education, can still understand. There is no lawyer needed, and there are no they're not like present in the document terminology which is too technical, and in this case the citizen can still read it. And then the other one, which would be an easy reading, would be aiming at the final user, which in this case would be a citizen which has very little instruction. We can also call it an alphabet, and in this case we need to make the text and the resolution very accessible without any of the terminology and even paraphrases.
Desde el punto de vista de la estructura de la resolución judicial, el lenguaje claro se aplica a la totalidad de la resolución, mientras que la lectura fácil únicamente en un apartado o en un considerando o en un párrafo especial con letras con un tamaño mayor, con resaltadas con negrita, con algún tipo de atractivo visual para que esa persona pueda enfocar su lectura y pueda hacerle mucho más comprensible a esa persona que tiene alguna dificultad especial para poder leer la totalidad de la sentencia y por lo menos tener una noción de qué se trata.
So the clear language, it's a strategy that needs to be implemented in the in the integrity of the document, meaning all the documents should be written and will be written in this clear language. Whereas the easy reading, it's usually implemented in just a little part of the test, maybe a paragraph where there is like a summary of the disposition, and it needs to be visually clear, maybe using another font or maybe using a different type of visual attractive system so that the reader can easily understand in summary what's going on.
Bien, ¿y cómo entra a jugar ChatGPT en esto de la simplificación del lenguaje, ya sea tanto en lenguaje claro como lectura fácil para personas en situación de vulnerabilidad? Bueno, el uso que se le da es un uso analítico. En realidad, cualquier inteligencia artificial puede servir para esto. Yo particularmente trabajé para esta exposición en ChatGPT, pero puede servir en Google Gemini, puede servir en Bing Copilot y cualquier otra similar. Uso analítico, ¿qué quiere decir esto? Que yo le voy a suministrar un material y le voy a pedir a través de un prompt o una instrucción que procese y que me arroje una respuesta a raíz de ese material que yo le suministro. En este caso, una resolución judicial. A diferencia de los usos creativos en los cuales yo incorporo un prompt y la inteligencia artificial se encarga de generar todo el contenido sin que yo le proporcione anteriormente un material específico.
Okay, so how can we use GPT for this purpose? We need to clarify the fact that in this specific case, ChatGPT was used, but however, any artificial intelligence system could actually do it. There was an analytic use and a creative use. An analytic use means that the artificial intelligence tool has been instructed with clear instructions and material to generate a final, let's say, text in this case. And a creative use, it's when we do instruct the artificial intelligence tool, but however, we don't provide any material.
¿Qué requiere el uso del ChatGPT en esta tarea de simplificar el lenguaje? Bueno, en primer lugar, prompts útiles. Hay que tratar de utilizar prompts que contengan la mayor cantidad de información y de contexto para que la inteligencia artificial generativa sea capaz de interpretar qué es lo que realmente nosotros queremos. Pero sobre esto no hay una receta única, sino que es un poco ensayo y error, es decir, hay que ir probando diferentes. Yo tengo una receta en particular, pero no quiere decir que sea una verdad revelada. Otra cosa, preservación de datos y seguridad, los datos de las personas. Antes de introducir información sobre personas, hay que pasarlo a iniciales o bien seudónimos para preservar los datos de estas personas y la seguridad también, preservar la seguridad de los sistemas. Conocer el tema y conocer la causa. Si no conozco el tema a nivel teórico o jurisprudencial, o tampoco la causa, es decir, no me leí el caso, no voy a poder revisar y controlar que el resultado que me arroja la inteligencia artificial generativa sea realmente lo que yo, digamos, se ajuste realmente a lo que corresponde, es decir, que no haya las llamadas alucinaciones que provoca este tipo de tecnología. Y por último, el toque personal. Siempre es posible darle un valor agregado propio del ser humano al resultado que arroja la inteligencia artificial. Yo creo que es un poco, en eso radica la importancia de utilizar estos sistemas como un asistente o un complemento y no un reemplazo de la persona humana, en este caso del juez.
So what is needed here? What do we need to actually feed an artificial intelligence tool to provide us with the relevant information? First of all, we need to use prompt, and this prompt should be useful and clear with a lot of information and context. Second, we need to accept the fact that there's going to be a trial and error path. So there might be some error, but we need to keep on changing and trying accordingly. And there is no single useful recipe. Maybe he has his own way of doing things, but we need to adapt it to each situation. Fourthly, the information about people, we should be careful and provide pseudonyms because it's, the identity of people should be protected. And then we need to know the topic very well, at least the theory. Otherwise, it's not possible to review the final result. And finally, we need a personal touch.
Bien, desde el lenguaje claro, el ChatGPT o GPT puede ayudar a mejorar el texto en 3 niveles del análisis lingüístico. El nivel léxico, es decir, el de las palabras, el vocabulario de un idioma, el nivel morfosintáctico, que tiene que ver con cómo la estructura interna de las palabras y cómo se relacionan entre sí, y las distintas palabras para construir unidades gramaticales mayores como enunciados, frases, oraciones, y el nivel discursivo, es decir, el nivel macro del texto en su totalidad, nos puede ayudar, por ejemplo, a mantener el hilo argumental, evitar reiteraciones, evitar contradicciones lógicas. Bueno, sobre esto no me voy a explayar porque quiero ir directamente, me queda poco tiempo, a el nivel, a la lectura fácil, perdón. Yo para la lectura fácil utilizo un prompt donde les suministro la siguiente información. En realidad son dos prompts encadenados. Un primer prompt donde le pregunto qué, cómo, cuánto y para quién. Y un segundo prompt donde hago el ajuste del tono. Porque la primera respuesta me la da en forma muy despersonalizada, muy fría. Y en este tipo de simplificación del lenguaje, en la lectura fácil, yo necesito una cercanía entre el juez y la persona destinataria de ese texto.
So first of all, has to be mentioned that how GPT can improve the text. There are 3 levels: lexical, morphosyntactical, and discursive, meaning that it's a way also to avoid contradictions. And we fast forwarding to the easy reading. How does he use his prompts? First of all, he uses prompts defining the what, how, when, and why, and then is gonna use another prompt to adjust the proper tone.
Bien, bueno, el ejemplo yo utilicé, acá ustedes no pueden ver mi pantalla, en todo caso puedo compartir después con los organizadores la presentación, un caso de adopción de integración de un niño. Entonces, lo que yo le pedí a través del primer prompt al ChatGPT fue: resume esta resolución judicial, entre comillas, utiliza lenguaje fácil y una extensión máxima de 100 palabras para que lo entienda un niño de 10 años. En el segundo prompt le pedí que hiciera lo mismo, pero en primera persona, como si tú fueras el juez y debes dirigirte al niño. La respuesta que arrojó el chat GPT es: hola, quiero explicarte algo importante sobre una decisión que debo tomar. Hay una familia que quiere formalizar su relación con un niño muy especial como tú. La adopción es cuando una familia te cuida y te quiere mucho, se convierte oficialmente en tu familia. En este caso, aunque el hombre que quiere ser tu papá no vive contigo y tu mamá, ustedes siguen siendo una familia unida. Mi trabajo es asegurarme que tomo la mejor decisión para ti. Creo que es importante que seas oficialmente parte de esa familia que te ama tanto y que puedas llevar su apellido si así lo deseas.
So the prompt that he used in a specific case was a case about an adoption of a child, and it was essential to produce a document in an easy language. First of all, a language that could be read to or by the child itself, but also another part of the text that was aimed to go to the actual judge, so how the judge was supposed to read this text. And basically what the text was, what the artificial intelligence produced was a text where it was explaining that, hey, there is a family that want to adopt you. You always be part of the original family, although you're not living together. I'm trying to, my goal here is trying to find the best solution for your interests.
Perdónenme, José Osvaldo, le ruego amablemente de ir hacia las conclusiones.
Bien,
Muchas gracias.
perfecto. Bueno, la inteligencia artificial generativa, siendo que los abogados en general y los jueces en particular trabajamos con la palabra, puede ser de gran ayuda a la hora de redactar estos textos escritos. Todo lo que hace la inteligencia artificial generativa lo puede hacer claramente el abogado o el juez. Pero la idea es justamente utilizar estas herramientas para potenciar nuestro trabajo, para hacerlo más eficiente y para poder hacer del servicio de justicia algo más accesible a su verdadero destinatario, que es la persona que solicita el servicio de justicia. Y para finalizar, quisiera terminar con una frase de Richard Susskind, quien hace más de una década dijo: En el futuro, la mayoría de los abogados no serán ni litigantes ni asesores, sino ingenieros legales. Tenemos que poner la tecnología a nuestro lado, porque el mundo ya lo hace. Como dijo Victoria recién, no dar la espalda a la tecnología y ponerla, como dice Richard, a nuestro lado. Yo creo que es importante, y no solo para estar al frente, sino para no quedarnos atrás. Muchas gracias y buenas tardes.
So the final point that he's making is that the artificial intelligence, in the end, in this case, needed to work with words. That's what lawyers do anyway. They work using words. And the artificial intelligence is supposed to help with this text that are produced, and to use it, and so to make the work a little bit more efficient, especially for the final user, which is a citizen. He concludes with a quote: "The future of the lawyer," that goes more or less like, in the future, the lawyers won't be lawyers, will be actually legal engineers.
Muchas gracias, José Osvaldo. Thank you very much, José Osvaldo. Let's move on. I will comment at the end. And after listening how magistrate judges are starting using artificial intelligence, let's have the point of view from lawyers. I will introduce Elena Bassoli, that she will speak in English, so that will help us understand also the way that lawyers see artificial intelligence, machine learning, and actually what's their thoughts on it. Please, Elena, the floor is yours.
Thank you. Good afternoon, everybody. And first of all, I thank the organizers for the invitation. My speech will concern the 5 fundamental principles of the European Ethical Charter on the use of artificial intelligence in judicial systems and their environment. This is the first European instrument to set out 5 substantial and methodological principles that apply to the automating processing of judicial decisions in data based on AI techniques. Developed by the Council of Europe's European Commission for the Efficiency of Justice, it is aimed at private companies, like startups active on the market of new technologies applied to the legal service or legal techs, public actors in charge of designing and deploying AI tools and services in this field, public decision makers in charge of the legislative or regulatory framework and the development, audit, or use of such tools and services, as well as legal professionals. And here are the 5 principles. Take a moment and just need a moment for share with you the slide. Sorry, slide. Not a document. Here it is. And here are the 5 principles of the Ethical Charter on the use of artificial intelligence in judicial systems and their environment. The first principle is the first respect for fundamental rights. Ensure that the design and implementation of artificial intelligence tools and services are compatible with fundamental rights. The second principle of no discrimination, specifically prevent the development or intensification of any discrimination between individuals or groups of individuals. The third principle of quality and security is with regard to the processing of judicial decisions and data use certified sources and intangible data with models elaborated in a multidisciplinary manner in a secure technological environment. The fourth principle of transparency, impartiality, and fairness make data processing method accessible and understandable, authorize external audits. 5. Principle under use control. This principle precludes a prescriptive approach and ensure that users are informed actors and in control of the choices made. But let's take a look to the details of these 5 principles. The first, respect for fundamental rights, says that the processing of judicial decisions and data must serve clear purposes in full compliance with the fundamental rights guaranteed by the European Convention on Human Rights and the Convention on the Protection of Personal Data. When artificial intelligence tools are used to resolve a dispute or as a tool to assist in judicial decision-making or to give guidance to the public, it is essential to ensure that they do not undermine the guarantees of the right of access to the judge and the right to a fair trial, for instance, equality of arms and respect for the adversarial process. They should also be used with due respect for the principles of the rules of law and judges' independence in their decision-making process. Preference should therefore be given to ethical by design or human rights by design approaches. This means that right from the design and learning phases, rules prohibiting direct or indirect violations of the fundamental values protected by the conventions are fully integrated. The second principle of non-discrimination. Given the ability of these processing methods to reveal existing discrimination through grouping or classifying data relating to individuals or groups of individuals, public and private stakeholders must ensure that the methods do not reproduce or aggravate such discrimination and that they do not lead to deterministic analysis or uses. Particular care must be taken in both the development and deployment phases, especially when the processing is directly or indirectly based on sensitive data. This could include supposed racial or ethnic origin, socioeconomic background, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health-related data, or data concerning sexual life or sexual orientation. When such discrimination has been identified, consideration must be given to corrective measures to limit or, if possible, neutralize these risks and also to raise awareness among stakeholders. However, the use of machine learning and multidisciplinary scientific analysis to contrast such discrimination should be encouraged. The third principle of quality and security says that designers of machine learning models should be able to draw widely on the expertise of the relevant justice system professionals, like judges, prosecutors, lawyers, etc., and researchers, lecturers in the field of law and social science, for example, economists, sociologists, and philosophers. Forming mixed project teams in short design cycles to produce functional models is one of the organizational methods making it possible to capitalize on this multidisciplinary approach. Existing ethical safeguards should be constantly shared by these project teams and enhanced using feedback. Data based on judicial decisions that is entered into a software which implements a machine learning algorithm should come from certified sources and should not be modified until they have actually been used by the learning mechanism. The whole process must therefore be traceable to ensure that no modification has occurred to alter the content or meaning of the decision being processed. The models and algorithms created must also be able to be stored and executed in secure environments so as to ensure system integrity and intangibility. The principle of transparency, impartiality, and fairness. A balance must be struck between the intellectual property of certain processing methods and the need for transparency, access to design process, impartiality, absence of bias, fairness, and intellectual integrity, prioritizing the interests of justice. When tools are used that may have legal consequences or may significantly affect people's lives. It should be made clear that these measures apply to the whole design and operating chain as the selection process and the quality and organization of data directly influence the learning phase. The first option is complete technical transparency, for example, open source code and documentation, which is sometimes restricted by the protection of trade secrets. The system could also be explained in clear and familiar language to describe how results are produced by communicating, for example, the nature of the services offered, the tools that have been developed, performance, and the risks of error. Independent authorities or experts could be tasked with certifying and auditing processing methods or providing advice beforehand. Public authorities could grant certification to be regularly reviewed. And finally, the fifth principle, under user control. User autonomy must be increased and not restricted through the use of artificial intelligence tools and services. In particular, the judge should be able to return at any time to the judicial decisions and data that have been used to produce a result and continue to have the possibility of departing from it, taking into account the specificities of the case in question. The user must be informed in clear and understandable language whether or not the solutions offered by the artificial intelligence tools are binding, of the different options available, and that he has the right to legal advice and the right to access a court. He must also be clearly informed of any prior processing of a case by artificial intelligence before or during a judicial process and have the right to object so that his case can be heard directly by a court within the meaning of Article 6 of the European Convention on Human Rights. Generally speaking, when any artificial intelligence-based information system is implemented, there should be computer literacy programs for users and debates involving professionals from the justice system. And finally, in my opinion, these include principles such as the primacy of law. The effect of these tools may be not only to provide incentives, but to be almost prescriptive, creating a new form of normativity, which could supplement the law by regulating the sovereign discretion of the judge and potentially leading in the long term to a standardization of judicial decisions based no longer on case-by-case reasoning by the courts, but on a pure statistical calculation linked to the average compensation previously awarded by other cohorts. This is actually the main risk I see in the near future. I thank you for your attention.
Thank you very much, Ms. Basori. And this is very important for the ethical perspective of using technology, in particular artificial intelligence. This would be my time for conclusion, but actually we have here to the stage Ryan Abbott, that was mentioned before, from Gerald Garcia. He is the lawyer that is bringing several of the cases of copyright for artificial intelligence. I would really like to listen from him. What is going on and what's happening? Ryan is connecting from Los Angeles very early in the morning. Thanks, Ryan, for being here. We have strict times, but we still have 10 minutes to listen. Please go ahead, and hopefully in 10 minutes we can grasp what's your message. Thank you very much, Ryan.
Oh, my pleasure. And very sorry to cut into your conclusion, but can everyone hear me okay?
Wonderful.
Great. Well, I'm trying to upload some slides here, but we may just have to do it without slides.
You can share your screen, and I will allow you.
Yeah. Stop cam. It says present, and it has slides uploading. I don't see a show screen button. Share screen. There we go. Okay.
Right. Wonderful. Here you are.
Well, that would require my computer to give new permissions and then reset and start back up. So I'm not sure we should do that. Oh, but you can see those slides.
Yes.
So that's through slide sharing. All right, good enough. Anyway, so I'm here to talk about some lawsuits that we filed that I think are kind of interesting. And with 10 minutes, we're going to do it real quick. These lawsuits basically concern whether or not you can protect AI-generated output with certain sorts of intellectual property rights. You know, the first being copyright, although we're perhaps better known for the patent cases. But there was a lot of academic discussion about this really for a long time because it was a theoretically very interesting question, but really no law at all, except a few laws. So the United Kingdom in 1988 changed their Copyright Act to say that if you have an AI-generated work, which they define as a work that lacks a traditional human author, that the work gets protection. It gets protection for a shortened period, 50 years from the date of creation, as opposed to 70 years from the life of an author. And the producer of the work, the person who undertakes to have the work created, is deemed or fictionalized to be the author. And this was done because in the 80s, the British Computer Society thought that you'd have widespread confusion in the creative industry if we didn't have clear rules. Well, it turned out to be 35 years ahead of its time, but here we are now with widespread confusion in the creative industry about whether, if you're using GPT or Gemini or Midjourney, and it makes something creative and valuable, whether you can own that sort of thing. The United States has gone the other direction. Since 1973, actually, they had a Copyright Office policy, though it was hard to find, that said if you had something made without a traditional human author, you couldn't have a copyright on it. And they cite to this very old case involving this picture of Oscar Wilde in support of that policy, and basically said copyright is designed to promote the fruits of, you know, creativity and the mind and the intellect, and AI doesn't have those things, and therefore there's no need for protection. And so there had really never been a case on this. There was one case involving a picture taken of a monkey that ended up getting dismissed, but dismissed on the basis that monkeys aren't allowed to bring lawsuits in the United States. And other than that, there had really been no case. And no one really cared about it too much until, again, very recently, with the availability of large language models. This is a piece of artwork that won a state art fair in America and was made using Midjourney. And the Copyright Office registered a copyright in it to the human author, the human artist. And when they found that he had used Midjourney from statements he made in social media, they canceled the registration. And so, again, there is now really very active commercial interest in owning this sorts of output. Right now, the Copyright Office's position has been, again, though, that Copyright Office only protects human creativity, and therefore you can't get protection. So this is a piece of art made by an AI system owned by a computer scientist named Stephen Thaler, whom I represent. And this work was submitted for registration to the Copyright Office in 2018, and they rejected it as being AI generated. And of course, you can't have an AI own a copyright because it's not a legal person and it wouldn't make a lot of sense. But there's plenty of reasons for people to own artwork made by AI systems. The US Supreme Court has said that in America, copyright exists to promote the generation and dissemination of works. And so if we want more creative works, then encouraging people to make and build AI systems that generate creative works and encouraging people to use those systems are going to achieve the goals of copyright law. And if we say, well, if a generative AI touches the creative process, there's no more protection, that's a real disincentive to using AI in the creative industry. And in fact, in the US, copyright law allows corporations to be authors, and there is no requirement to disclose any sort of human contribution to a work whatsoever. So we filed this case in the District of Columbia District Court, which ruled against us. It is now before the District of Columbia Appellate Court, and we have recently filed our opening brief. So we will see what the District of Columbia Appellate Court says, but it is the first case in the United States to argue this. And if it rules against us, Congress has already started debating whether or not they want to amend copyright law. Of course, different jurisdictions have different goals of copyright. France, for example, has it primarily to protect the moral rights of human authors. So not every jurisdiction may want a system that promotes the generation and dissemination of works, but these are very much kind of topical issues around the world, as are a dozen lawsuits that have been filed about whether it's infringement to train machine learning systems based on someone else's protected work, along with a whole other group of causes of action based on generative AI allegedly infringing in some way some IP right. We also filed a series of test cases on patent law. So this green thing is something that is a car suspension, and the silver thing is a car suspension made by a team at Siemens. And Siemens was unable to file for a patent on the silver car suspension because the inventors, the human inventors, said that the AI invented it and that they hadn't really done anything inventive, that the problems to be solved were well known, the output was obviously valuable, they had an AI that optimized industrial components, they weren't willing to say they were inventors, and as a result, you couldn't get a patent. Well, similar to the copyright theory, that's not a good outcome. If patent law exists because we want to promote innovation, commercialization of new inventions, and disclosure of confidential information or trade secrets, then we want that system to function regardless of how inventions are made. We want to encourage people to make and use inventive AI to help find new drugs or make better car parts or make you name it. And right now, it's not clear the patent system is going to do that. So there was even less law on the patent front about what to do with an AI-generated invention than there was with an AI-generated work. So we had an AI make two inventions. One's called the fractal container. It's this beverage container shown here. We had 3D printed. Again, a machine predicted this would be easy to grip and that it would increase surface area, so improve heat transfer. It was, in fact, very easy to grip, although very difficult to drink out of and impossible to clean. But it is just an invention, not an actual commercial product. And so we filed this now in 17 jurisdictions and said, well, this was invented by an AI, and the person who owns it is the owner of the AI. And we had a patent issued in South Africa and should soon have one issued in Saudi Arabia. A first level federal court in Australia held that under the Australian Patent Act, an AI could be an inventor and that the person who owned the AI system would own the invention. That decision was overturned on appeal. The European Legal Board of Appeal ruled that you cannot have an AI listed as an inventor but that there's no particular requirement for inventorship in European law. And as a result, the user or the owner of the AI can be listed as an inventor, and the specification can even state that an invention is AI generated. So we refiled the applications, are waiting on decisions on that. In Germany, 2 federal appellate courts have split on this and sent it to their Supreme Court. Last December, the UK Supreme Court ruled on this and said, you can't protect an AI generated work, although it didn't give the level of contribution that a person or a machine would do. But if you didn't have a human being who had been a deviser of the invention, you simply couldn't get a patent. So that was the UK Supreme Court approach. And the US Federal Circuit said something similar and basically said, if you don't have a traditional human inventor, you can't get a patent. As a result of that, a couple of weeks ago, the US Patent and Trademark Office put out a new guidance basically saying what a human being had to do to get a patent on an application. And it is more than simply prompting a generative AI or relying on a generative AI to do most of the work. So this is important in the United States, where if you have the wrong inventorship, you can invalidate a patent in litigation. And so we are likely to see as a new defense to patent infringement, you don't have human inventorship in your patent or accurate inventorship. Really, a lot of work was done by a generative AI. But of course, again, this isn't a good system if we don't really care how something was made. We just want to promote innovation. And this is going to be a particular challenge as AI gets better and better at making creative works and inventive contributions, and human beings don't. So that was 10 minutes, and I will stop there.
Thank you very much, Ryan. We were really looking forward to hear from you this advancement and this challenge that we are seeing. I would like to thank you, all the speakers, all these pioneers in this field that is still open, still uncertain. I took some notes that I will make available in a separate short video after the conference. And because I think it's my pleasure now to introduce the keynote speaker of this session, Professor Martin Ebers. Professor Martin Ebers is a distinguished figure at the intersection between law and technology, and I follow him since many years, actually. Professor Ebers is the president of the Robotic and AI Law Society in Germany. He is a professor of IT law at the University of Tartu in Estonia, which I think she's now in Estonia, or she's going to Estonia. Well, we will see. Dr. Ebers leads background research project, including project exploring private rule making and European governance of AI and robotics. This afternoon, Professor Ebers will help us understanding a bit better the regulation upcoming in Europe, the AI Act, and hopefully its implication in the legal sector. Please, Professor Ebers, thanks to be with us. The floor is yours.
Yeah, thank you so much for this warm welcome. Indeed, greetings from Estonia, or more specifically from Tallinn. That's actually where I am right now. But after my talk, I have to head directly to the airport. So I also have to stick to the time, which is, of course, a little bit challenging, given that the AI Act, where recently a political compromise was reached, actually has a lot of things we could discuss, and of course also consequences for the legal sector. So now I would like to share my screen. I hope it's possible. I have to see where.
You can go to present, share screen, and that will allow you on the floor.
Present and slides or video? No, share screen.
Share screen.
Yes, I did this already. Allow streamer to see your screen. Okay, I have to allow this, but I cannot do this. No. Share screen. Okay. Select screen. Okay, here we go. Just a second. So now you should see my screen, hopefully.
Yes.
Okay, wonderful. So where are we right now? Well, there is almost a final text available right now, but still the final version will be most likely available in April. So I think the numbering will still change. It looks right now quite chaotic, and also language wise, only the English language version is available and the others are not. Well, when we talk about the AI Act, then we have to take into account that the AI Act is not the only piece of regulation. Basically, the AI Act is based on the overall design of product safety law. The main goal of the AI Act is to make sure that AI systems, before they are released on the market, are safe enough and do not pose significant risks to health, to safety, but also to fundamental rights. But there's also other product safety regulation in place. Two recently adopted regulations, the General Product Safety Regulation and also the Machinery Safety Regulation. And then regarding specific products, we have a lot of other EU acts here that also regulate like product safety law. And there's some overlap with the AI Act. And then once an AI system is on the market, still things can happen. And it might be that an AI system causes a damage. And therefore, we will have also, together with the AI Act, a new product liability directive. The old product liability directive is of 1985. And with a view to new technologies, it was necessary to adopt here a new product liability directive. So this will be also adopted under the current European Parliament and under the current European Commission. The other proposal, the AI liability directive, though, will not be adopted in this term due to various reasons. So now let's have a closer look at the AI Act. I will especially deal with high-risk AI systems, but before doing so, I would like to give you a short overview. So as you all might be aware, the definition of AI is one of the most contentious issues, and actually until the final agreement was reached was still very much in progress. So what is now the definition of an AI system? Article 3 follows basically the OECD definition, according to which an AI system is a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment. So these are basically the two elements, varying levels of autonomy, and that there may be some kind of adaptiveness. Now, the problem with this definition is that the AI Act does not tell us the threshold of automation from which on we can say this is an AI system. So it just refers to varying levels of autonomy. And also regarding the adaptiveness of the system after deployment, the text just says it may exhibit adaptiveness. The recitals are a little bit more revealing because the recitals say that the definition should not cover systems that are based on rules defined solely by natural persons to automatically execute operations. On the other hand, the definition is still broad because the recitals also refer not only to machine learning approaches, but also to logic and knowledge-based approaches that infer from encoded knowledge or symbolic representation. The only kind of systems that are out of the scope is then basic data processing, and this in itself, I think, is still then a very broad definition. So you can say basically a lot of software systems fall under the definition of an AI Act. Now, who is actually covered by the AI Act? Well, for one, providers that place the products on the market or puts the system into service, but also deployers that are basically those that use an AI system under their authority. There can be both private entities, but also public authorities, and even third country providers and deployers are covered where the output produced by the system is used in the European Union. Then I think we are all aware of this risk-based approach, according to which the higher the risk, the stricter the rules. So we have one article, Article 5, that regulates AI systems that are prohibited because they actually have an unacceptable risk. Then most of the AI Act is about high-risk AI systems. They are permitted, but before they can be released, they are subject to mandatory requirements and this ex-ante conformity assessment. Then we have AI systems that are subject to transparency obligations, and then we have those that have no or minimal risks. Now, this was actually the idea of the European Commission before generative AI came into play and ChatGPT was released. And therefore, so to say, in the last minute, there were introduced also rules on so-called general purpose AI systems, so JEPI. This is a little bit against the risk-based approach, basically for two reasons. One reason is the AI Act actually originally did not intend to regulate a certain technology, but of course the provisions on JEPI are pretty much about a certain technology. And second, the AI Act was about the concrete risks of concrete use cases, whereas the provisions actually regarding JEPI are not about a concrete use, because at the moment where generative AI is being developed, it is simply unclear for what use they will be used later. So then what is basically the timeline where the AI Act still has to be published in the official journal? After that, already 6 months later, the rules on prohibited practice are enforceable. 12 months later, then the rules on general purpose AI systems come into force. 24 months later, then the Annex 3 high-risk AI systems provisions and the transparency obligations are applicable, and 36 months then for the Annex 2 high-risk AI systems. The AI Act itself leaves a lot of questions open. So therefore, it remains to be seen how this act, how this regulation will be implemented. And this depends pretty much on the European Commission, because the European Commission will issue guidelines on the interpretation of the AI Act, how, for example, to understand the definition of AI, but also many other aspects of the AI Act will be interpreted by the means of guidelines by the European Commission. The European Commission has also the power to adopt implementing and delegated acts. And especially in the field of JEPI systems or models, the European Commission will approve a code of practice. And last but not least, also the European standardization organizations, CEN and CENELEC, are right now developing standards which once when they are published in the official journal of the European Union, become harmonized standards, and providers following these harmonized standards then can enjoy the so-called presumption of conformity. So if they can show that they followed these harmonized standards, then there is the presumption that their AI system is in conformity with the system. Now, what is the problem? The problem is all these rules enter into force already 6 months, 12 months, up to 36 months into force, whereas the guidelines, the implementing delegated acts, and all of that have no clear timeline. So that might cause a lot of insecurity. Now, I would like to point out especially here the following. Now, when we look especially at the judicial system, then Annex 3 comes into play, and especially the last point. The administration of justice and the democratic process is an area that is regarded as a high-risk area. So if you use an AI system there, if a judicial authority uses an AI system there, it qualifies as an AI system. But there is also a so-called additional layer that was introduced also during the negotiations. And this additional layer makes it possible that even if a system qualifies as high risk, then the provider has the possibility to say, well, this still does not qualify as a high-risk AI system. Because if the AI system does not pose a significant risk of harm to health, safety, or fundamental rights of natural persons, then actually then the provider has to document this assessment. The national authority has access to this documentation on request, and the provider has to register the AI system in the EU database. But the bottom line is that then the AI provider does not have to follow the rules of the AI Act regarding high-risk AI systems. I can see that my time is already over. If you would still give me 2 more minutes, there's a lot of obligations of providers. There's lots of obligations also of deployers of high-risk AI systems. For instance, deployers also have to control the input data and make sure that the input data is relevant. They have to monitor the operation of the AI system, and even it is necessary to carry out a fundamental rights impact assessment if this is a body governed by public law, and that is of course the case if it is a judicial authority. But judicial authorities using a certain system, for example, ChatGPT, under certain conditions can be even regarded not only as deployers, but even as providers, because according to the AI Act, if they modify the intended purpose of an AI system, including a non-high-risk JEPI, then they qualify as providers of AI systems. Let me conclude. I think by and large, the AI Act is a good piece of legislation, but it has some flaws. For example, the coherence is not there. The AI Act will overlap, interfere, and also contradict with existing EU laws. Then the AI Act does not really follow a true risk-based approach. There's lots of compliance costs and regulatory burdens, especially for small and medium-sized enterprises. There's also lack of safe harbors, and there's a lot of legal uncertainty until the European Commission will have issued guidelines and also adopted implementing and delegated acts. Thank you very much for your attention.
Thank you very much, Professor Ebers.